This conference will now be recorded.
So I'd like to welcome everybody who's joining today. And thank you for joining me on Friday, September 25th, 2020. And today we're going to be talking about the 5 primary reasons that fiduciaries need to consult with an elder law attorney. Bear with me, we're having an internet issue. Okay. So we're ready to get started, and we're going to start with some basics. And that is understanding how to identify if you're a fiduciary and the standards that a fiduciary must meet. So one of the very first people we encounter fairly often that's a fiduciary is the person who's named as the agent under a durable power of attorney. This document allows people who are over age 18 to designate a trusted, responsible individual or individuals to make financial decisions should the person who creates the document become incapacitated. And that could mean either a physical incapacity, a mental health incapacity, or a cognitive incapacity, or any combination. So the agent named in that document is a fiduciary. We also refer to them as the attorney in fact. It does not mean that they are a legal attorney who went to law school, but they are considered an agent. The second kind of fiduciary we encounter very often is the person named as the healthcare surrogate in a designation of healthcare surrogate, which is a form of a medical advance directive that allows a competent adult to name a trusted person to make healthcare related decisions for them should their ability to do that be compromised. When would it be compromised? Well, an example would be if somebody had a car accident and they hit their head and they're unconscious, they're not going to be able to make their own healthcare decisions. Or they could be conscious, but because of the injury, it is impacting their ability to take in information, to use their reasoning skills, their judgment skills, and to make an informed medical decision. So a surrogate is going to stand in the shoes of that adult and speak for them. Now, if you have or you know somebody who has a trust agreement, and there are many different types of trusts, some are revocable, some are irrevocable, the person that is named the successor or the alternate trustee in the legal document is also a fiduciary. They will be stepping into the shoes of the former trustee who is now either incapacitated, resigned, or has died. So they are also held to a fiduciary standard in carrying out their financial responsibilities. We see another kind of fiduciary when a person dies and their last will and testament is filed and admitted to the probate court. That document will name a fiduciary called a personal representative. And their job is to administer the probate assets, follow the rules of the court, and distribute the assets to the named beneficiaries. So they also have financial responsibilities under the document. And last but not least, a legal guardian who is appointed by a court to make either medical or financial decisions for an incapacitated adult or a minor aged child is also a fiduciary that is held to certain medical or financial standards. So now that we know the different categories of fiduciaries, what does it actually mean? Is it different than, let's say, when we're acting as a son or a daughter, a husband or a wife? And the simple answer is yes. A fiduciary is given a position of trust, of responsibility to act for another individual. So there is a specific standard of care that the fiduciary is expected to meet, whether it's making medical decisions or financial decisions. And basically, the fiduciary must act in the best interest of the principal, the person that is incapacitated and is no longer able to either speak, communicate, or make their own decisions. Now, there are many different statutes in Florida that provide us with guidance on the standard of care. So if somebody is a trustee, we look to the Florida Trust Code. If the fiduciary is a personal representative, we look to the Florida Probate Code. And if they're a guardian appointed by a judge, we look to the Florida Guardianship Law. Whenever the fiduciary is entrusted to make financial related decisions, we have one other place that we need to consult, and that is Florida's Prudent Investor Rule. It provides great guidance as to what the fiduciary must consider when making a decision about investing. For example, the fiduciary, whoever they are, trustee, guardian of property, agent under power of attorney, must take into account the age of the person they're acting for. Why would age be important? Well, the younger somebody is, there might be a greater likelihood that the person could work, and by working, they can supplement their income. Where somebody who is older is less likely to be able to be employed, and that has to be taken into account in determining what is a prudent investment for this individual. The fiduciary under the Prudent Investor Rule also has to take into account the health condition of the individual, and that relates directly to projecting the cost of health care and whether those health care costs can be met solely through various types of health insurance, or perhaps the fiduciary may need to use the assets and the income of the person that is incapacitated. So the Prudent Investor Rule is an important place for every fiduciary to start their responsibility. And depending on the fiduciary's level of education as well as employment history, they may need the guidance of an elder law attorney to help them understand how to apply not only the Prudent Investor Rule, but all the other statutes that I've mentioned. What is very important to understand is that the Prudent Investor Rule and the statutes should not be ignored. If they are not followed, there is potential liability for that fiduciary when the standard of care is not met. And it is not a valid legal defense to say, I didn't know about the rule or I didn't know about the statute. And that's why seeking proper legal guidance is so important for every fiduciary. So one of the first reasons that a fiduciary will want to call upon an elder law attorney is to learn how to properly use the legal document they are named in. Because the first step is to understand the document, and with it, understand how do you get your legal authority honored, whether it be by a financial institution or perhaps a medical provider. And from there, we want to understand how to properly advocate for the person that cannot speak for themselves. So we're going to look at a few of the different types of legal documents because each document will require a different trigger, a different element to be met in order for the fiduciary's authority to be recognized. So we're going to begin by looking at the durable power of attorney. This is the document I explained gives certain legal permission for a trusted person to make financial decisions. Now, we did have a change in the law in Florida in the year 2011. So depending on whether the durable power of attorney was signed prior to the change in the law versus after the change in the law will have an impact on the steps to take to have the fiduciary's authority honored. Now, while we don't have the benefit today to examine each person's own durable power of attorney, I can give you some guidance and then you'll take a look at the document. And certainly if there are any questions or you're unsure about anything, I encourage everybody to schedule an appointment and let's sit together and look at the document. Now, before the change in the law, which became effective October 1st of 2011, attorneys had the ability to write a power of attorney in one of two ways. The first way is we could have language that said, this durable power of attorney is not effective until my treating physician examines me and determines that I lack the ability to handle my financial affairs. And that would have to be put in a written affidavit. Now, if a power of attorney written before October 1st, 2011 had that language, we would call that a springing durable power of attorney. Springing meant that it comes into effect sometime in the future, only when the principal is actually incapacitated. The second way we could write the power of attorney was that it was effective the minute it was signed. And we refer to this as a non-springing durable power of attorney. So as soon as the ink was dry, the document was effective. When the Florida legislature decided to change the law, it got rid of the opportunity for us to write springing powers of attorney. So every durable power of attorney written after October 1st of 2011 is considered effective immediately. That means there is no trigger, there is no requirement that has to be met in order for the agent's authority to be recognized. It doesn't require a doctor's letter, for example. But if it's a springing durable power of attorney, you are going to need that affidavit from the treating physician. You will take that affidavit along with the durable power of attorney when you go to the financial institution and request that they honor your authority. Now, regardless of whether the durable power of attorney is springing or non-springing, Florida has another requirement. And so a financial institution can ask the agent to sign an affidavit that protects the financial institution. And this has been the law for many, many years. So what this affidavit says is that the person who gave you the durable power of attorney is still alive. The reason that language is in the affidavit is because by law, the power of attorney ends at death. It has served its purpose and it is over. The reason the bank wants this language in the affidavit is to protect it in case the agent does not tell the bank that the principal is deceased, and they then go into the account, clean out the account, and the beneficiaries then try to sue the bank. So this affidavit protects the financial institution. The second statement that will be contained in the affidavit says that the principal, the person who made the power of attorney, has not revoked, they have not canceled the document and changed their mind. Again, this is meant to protect the financial institution in case the agent is lying and does not tell the financial institution that the document was previously revoked. The last statement that is in the affidavit says that there is no guardianship or incapacity proceeding pending in the court. Now, why is this language important? It's important because our statute says if somebody files a petition to determine the capacity of the principal or to seek the appointment of a guardian for the person who made the power of attorney, then the authority under the durable power of attorney is temporarily stayed until the judge has a hearing and makes a decision. So this requirement protects both the principal as well as the financial institution. It is a standard form that can be found in the statute. So whether you have your elder law attorney prepared for your signature or the financial institution prepares it, it should be written the same way and should not have any other requirements in the document. So this affidavit will be needed before your authority will be recognized and before you will have permission to access the assets of the principal. Now, does a power of attorney have a requirement to prepare an accounting? That is going to be dependent on how the power of attorney document is written, and each one could be written differently. Even if the document does not require an accounting, I do highly recommend that anybody serving as an agent under a durable power of attorney keep good financial records, whether it's by hand or preferably on a computer program such as a Quicken software or a QuickBooks, or even creating an Excel format. I also suggest that you keep not just the paper copies, but scanned copies of the financial records, as well as records for any purchases that are made. Now, when it comes to advocating, it's important to know that you want to be clear in the words you use, whether you're speaking with a financial institution or you're putting a request in writing, and you want to document. It is not unusual to find that it can take a while for a financial institution to have its legal department review a power of attorney before deciding to honor it. And it's equally not unheard of that some financial institutions have not trained their customer service representatives well, and those people don't know to send the power of attorney to the legal department. They will simply review it themselves, and many times will tell the agent, I'm sorry, we can't recognize it. You have to use the bank's or the trust company's own form for a durable power of attorney. Now, this is where being an educated and strong advocate is very important. Probably by the time you are walking into the bank or you're walking into the brokerage house, the person you're about to act for is incapacitated. So it would make no sense to give them a durable power of attorney from the institution to sign because they wouldn't know what they're signing. And we don't want a person to sign something they cannot understand. It could be misperceived as taking advantage of them. So to be a strong and an effective advocate, you want to simply tell that customer service representative that no, they should not be giving you their own format, and no, they cannot require the principal to sign it, especially when they're no longer competent. you want to then direct them to speak with their manager and or their legal department. Now, hopefully, when you get to that point, they will have it properly reviewed and they will accept it. But if for some reason they don't, that's where you most likely want to get an elder law attorney involved so that we can speak the same language to the manager or to the legal department for them to understand why the power of attorney is valid under Florida law and needs to be recognized. The next legal document that you may be in a position to have your authority recognized under is the designation of healthcare surrogate. This is the medical document that names a trusted person to make healthcare decisions. So the first step that needs to be taken is to have the principal's capacity assessed, preferably by their treating physician who knows them. If that doctor is of the opinion after the assessment that this person's ability to give informed medical consent is compromised, we then want them to put that in writing and to give you a copy so that you can then show it to any healthcare provider, whether it be a hospital, a doctor, a specialist, a home health agency, or a residential facility. Okay? Now, if for some reason the primary physician is uncertain whether the principal who made the document lacks capacity, then we need a second independent physician called in. And depending on whether that person finds that the principal lacks the ability to give informed consent will determine whether your authority can now begin. So it needs to be documented that the principal cannot give informed medical consent, and documenting it is very important. Now, one of the things that you need to be aware of is that in 2015, the Florida legislature made a slight change to the designation of healthcare surrogate statute. And any document that has been signed after 2015 gives the consumer the opportunity to make two new decisions. The first decision that will be reflected in the document will say whether the document is effective now, meaning the surrogate can start to act immediately, or whether the surrogate can only act in the future when the doctor determines that the patient is incapacitated. The second decision that will be reflected in the newer healthcare surrogate designations has to do with the timing of when the surrogate can access confidential medical information, or what we refer to as the HIPAA law that protects a patient's confidentiality. Again, the choices that each consumer has is to give their surrogate permission to access confidential information immediately, meaning even while the patient is competent, or only to exercise that access to the information in the future when the patient has been determined to lack the ability to give informed medical consent. Now, just like we spoke about with the power of attorney, it's important to understand how to advocate, and especially when we're dealing with a medical event, because sometimes it's an emergency or a crisis, so the situation can be more emotionally charged than during normal times. So the best advice I can give a medical fiduciary is stay calm, speak clearly, have the copies of the medical advance directives with you, whether it's on paper or perhaps you might have it on a thumb drive and be able to send an electronic copy to the doctor, to the hospital. What happens if they're not recognizing your authority? Maybe they're not sure how to proceed. Well, if the patient is in a hospital setting, you want to ask to speak with the risk manager. Every hospital will have a risk management department, and somebody will be on staff and reachable, whether it's during the day, the evening, or the weekend. So that is the person that you want to be able to communicate with. They are going to be your ally to make sure that the medical advance directive is properly honored. Now, if for some reason the risk manager at the hospital or the facility is not honoring it, that's when you want to request in writing the basis for their decision, and you want to immediately consult with an elder law attorney so that the next proper step can be taken, which might mean we go to court on an emergency basis to compel the healthcare provider or the facility to honor the advance directive. But we have to first understand why they are basing their decision not to honor the designation of healthcare surrogate. What if you are named a fiduciary under a revocable trust agreement? Well, there can be different standards that trigger the successor trustee's authority. Not every trust document is necessarily drafted the same way. I will give you an example of what I have seen over the years tends to be the standard that is used. And the standard that is used is that two physicians must each examine the initial trustee, and if both of the physicians agree that something is affecting the trustee's ability to carry out their fiduciary duties, it could be an illness, a disease process, an accident that the trustee has been involved in, and they are willing to document that in writing, then the successor trustee would take that with the trust agreement and go to each of the financial institutions to request that their successor trustee authority be recognized. Now, what the financial institution will do, similar to being presented with a durable power of attorney, is to have it reviewed by the legal department. And once they have the approval from the legal department, they would prepare signature cards for the successor trustee to sign. They will request to be able to make a copy of a photo identification for the successor trustee. And they may have some other documents that relate to the requirements under the Patriots Act, stemming all the way back to 9/11. Once they have all that documentation for their file, they would then allow the successor trustee to begin to act under the document. And what the successor trustee will want to do is make sure that copies of monthly or quarterly financial statements are sent to the successor trustee, either paper statements or by electronic format. They will also want to notify the accountant that has been working with the former trustee that the former trustee is now no longer acting, and to find out what was the last tax return that was filed either for the trust or for the grantor, the person who created the trust document. So it's very important to find out where the status of any tax returns stand, whether there's an extension that has been requested, and what is needed, what can the successor trustee do in order to facilitate returns being properly and timely filed. Now, the question of whether a trust accounting is required is again dependent on how the trust agreement is written. When I write a trust agreement, I require a trust accounting to be prepared on an annual basis. And I do recommend that a successor trustee who is stepping in also prepare an inventory to document the assets that they are taking possession of as of the date their authority is recognized. So it establishes a baseline should anybody question what happened to the assets during the transition process from the former trustee to the successor trustee. We also have to read the trust agreement because it may provide for what the Florida Trust Code calls a designated representative. So a designated representative is somebody who the grantor designated in the agreement to receive things such as the inventory and the accountings while the grantor is incapacitated. So we want to read the trust agreement to know, is there a designated representative? Who is it? And to make sure we then serve a copy of the inventory and the annual accountings on that individual. It's also important to make sure that the accountings are served in a way that the successor trustee can document that they were received. So preferably we want to use certified mail return receipt or some other standard such as Federal Express that requires a signed receipt. So we know that the accounting was received. And why is that important? Well, under the Florida Trust Code, there is a limited period of time that we want to inform anybody served with the accounting that they have to object to the accounting or to bring an action under the trust code. So again, these are all important reasons to be represented by a qualified attorney that can guide you through the process of being a fiduciary. The second important reason to call upon an elder law attorney is to understand the financial duties and responsibilities that come with the role of an agent under a power of attorney, a successor trustee under a trust, a personal representative under a will, or a guardian appointed by a court. So record keeping is so important. For example, in guardianship law, a guardian must maintain the records of the finances for a period of 3 years after they have been discharged as the guardian and the guardianship has been closed, either because the incapacitated person has died, or if it's a minor and the minor turns 18 and they become a legal adult, we close a guardianship for that reason. So it's very important to have a record-keeping system that is reliable, that is accessible, and most important, to have a backup system. We want to be prepared if a court auditor does a random audit of a guardianship, and similarly, should somebody question the authority of the fiduciary and make an anonymous report to Adult Protective Services, they could very well do an investigation into the finances. So as a fiduciary, you don't want to wait for that to happen. You don't want to be fumbling and trying to put together records at that point in time. You want to have a system that you've been following all along so you're prepared if anything like an audit or a review were to happen. I've already mentioned the importance for many fiduciaries to conduct an inventory. And I want to mention that if you're responsible for real estate, it's probably also important that you get a formal appraisal of the real property, that you do an inspection initially, as well as throughout the year, especially if you're not living at the real estate. You want to be inspecting it to make sure that it's being properly taken care of by whoever is living within the premises. And most certainly, you want to make sure that you are properly insuring the assets. So if there's real estate, you want to make sure there's a homeowner's insurance policy that is current. And depending on where the property is located, you might also need to look into flood insurance. If, let's say, assets you're entrusted with might include jewelry, you want to make sure you've obtained a jewelry appraisal and that the homeowner's insurance policy includes a jewelry rider. to protect those assets. We've mentioned an annual accounting. We've also mentioned the importance of working with a qualified certified public accountant to guide you through tax and accounting issues. Now, don't forget that every state has what is called the Division of Unclaimed Property. And most divisions at this point in time have everything electronic, meaning they have a website which you can go to, and I recommend doing a search of the name of the principal that you are acting for. And the search will tell you if there's any unclaimed property coming up in their name in that state. It will also tell you the last known address that was on file for the financial institution that was holding that asset. It may or may not describe what the asset is. Most of the time I find it will tell us, but once in a while there is no description. So what you want to do is attempt to determine if that last known address that comes up in the search result matches a place that the principal once resided. And if it does, you want to go through the process online of completing the claim form and submitting your authority for the claim to be processed. And as always, it's important to communicate as a fiduciary with government agencies. That could mean acting for the incapacitated person and notifying the Social Security agency of who you are. You might have to become what is called the representative payee for the person who's not able to manage their Social Security benefit. It also might mean that you have to communicate with the Veterans Administration if the person who's incapacitated is a veteran or the spouse of a veteran and is receiving veteran benefits. Now, just like there are duties and responsibilities as a financial fiduciary, there are similar duties as a medical fiduciary. So the primary duty is to select qualified physicians or specialists that the principal might need. Now, it does not mean that you have to be an expert in the healthcare system, but it means that you need to seek the advice from people that are. And one of the best professionals that we have, and it's not just in Florida, but in every state, are called care managers. Some care managers have the expertise and the training to work with an older geriatric population, and they can help you navigate through the healthcare system. They can help you find the qualified and appropriate physician for the incapacitated person. There are also care managers that specialize in working with younger people. So perhaps if you're the fiduciary for somebody that has a developmental disability or special needs, they're going to be able to guide you in the right direction and help you navigate that part of the healthcare system. So you don't have to be an expert, but you do need to know how to find the right resources, and that's something that an elder law attorney can help you with. The care manager can even help you with coordinating the medical appointments and getting the person to and from the appointment. Let's say you're a fiduciary who works, or you're a fiduciary located out of state, and maybe you cannot attend the medical appointment with the principal. You could ask the care manager to be there for you. So they become your eyes and ears on the ground, and they can report back to you what happened at the appointment, what was discussed with the doctor, and is the doctor recommending testing, therapies, what is the treatment that is being suggested. So they can help with all phases from the initial assessment through the implementation process. Care managers can even help a fiduciary determine the best ways to make the home environment safe. Safe for a person that perhaps is starting to have cognitive impairment, or say for a person that is having some physical challenges and physical limitations. And that leads directly into having a conversation to understand what are the best residential options for the person you're caring for. And if you're the financial fiduciary or you're working with the financial fiduciary, then the finances becomes part of the discussion of, can we keep this person at home? Can we make it safe? And how can we maximize the finances that are available to pay for the care either under traditional health insurance or through government benefits? And what's most important, let's not forget, is to locate any other advance directives that might exist and that are going to provide guidance to you as the medical fiduciary. So you want to look for things such as a living will that might have been signed, a HIPAA authorization, an organ donation declaration, and even a do not resuscitate order. It's going to help guide you through the process, especially if the person who's incapacitated is no longer able to express and tell you what their preferences are, or even how their religious beliefs or their cultural beliefs might impact the types of medical decisions they would want you to make for them. The third reason for a fiduciary to work with an elder law attorney is to become informed about long-term care planning options. So we have health insurance, which depending on the age of the person might be insurance available through employment. But if they're no longer able to work, the only way that would continue is if they pay a premium through COBRA. So for somebody that is retired, it's most likely going to be health insurance benefits through Medicare, or perhaps they chose an HMO policy. So there are many different levels of coverage depending on whether a person has Medicare or an HMO. And that is very involved, too much for us to discuss in today's webinar. We'd need a webinar just about that. But again, you want to work with a qualified elder law attorney to help you navigate through the health insurance issues. You might be faced with a decision of perhaps disenrolling the person from an HMO and enrolling them in traditional Medicare because it might end up providing a better array of benefits. You also want to be looking to find, is there a long-term care insurance policy? This can provide wonderful options, not just for where the care will be provided, but what the level of payment, the level of the benefit is going to be. So this can help you plan long-term. How long will the private resources last for before we then have to look to certain government benefit programs? So definitely look through the financial records, see if you find checks that have been issued to pay a premium. Look at the tax records because tax records will alert us to whether there was a deduction taken on the tax return for the premiums paid to keep a long-term care insurance in place. When we go through those issues, sometimes it means that the long-term care insurance will carry the individual for a period of time, and we don't need to turn right away to government benefits. And sometimes it might be that we're going to use the long-term care insurance policy at the same time we're going to explore government benefit programs. So for example, it's important to know, is the incapacitated person a veteran or a spouse of a veteran? There may be benefits available that have nothing to do with whether they were injured during their service time, and we refer to that program as aid and attendance. So to qualify for that program, we have to look at the resources, the income, and the unreimbursed medical expenses, meaning medical expenses paid out of pocket and not reimbursed by any type of health insurance program. So we'll go through a process together of evaluating, can we obtain this financial stipend from the Veterans Administration to help pay for the cost of care, whether it's used to pay for the home health agency so the person can stay in their private residence, or perhaps it'll be used to help pay the cost of room and board in an assisted living facility or even in an independent living facility. We also want to make sure that people are getting the maximum Social Security benefits that they are entitled to. So if the person you're acting for had a spouse that passed, it's important to report the death to Social Security and have them look up their records for both the deceased spouse and the living spouse to determine who was the higher wage earner. And based upon who was the higher wage earner, will then tell us what the new benefit amount should be for the surviving spouse. We might also want to explore Medicaid assistance. Medicaid has many different programs. It can pay for care provided in the community, such as in a person's own home or a relative's home that they might be living with. It can also pay for some care in assisted living, and it pays a higher level of care in a skilled nursing facility. So we want to talk about how do we coordinate all the different possible options to pay for the long-term care of the individual that you are the fiduciary for. The fourth reason, and a very important one to consult with an elder law attorney, is if you suspect that the person you are the fiduciary for is being abused, neglected, or exploited. We have legal tools to stop the abuse, the neglect, and exploitation. And the earlier that you consult with an elder law attorney, the sooner that person can be protected. So one of the first tools that we have to use is an emergency temporary guardianship. Now, this allows us to get into court very quickly when we have evidence, and evidence can be testimony of a witness. It could be, if it's exploitation documentation, such as a bank statement, that would show the individual is being physically abused, emotionally abused, verbally abused, or perhaps they are being self-neglectful. They're not eating properly, the food in the refrigerator is stale, they did not renew their prescriptive medication, the medication vial on the kitchen counter is empty, or they're being financially exploited. They're giving away assets to, let's say, a scam artist, or perhaps they've been encouraged to write out a check payable to the home health aide, or a large check to a family member, or somebody that has recently befriended them, but for all intents and purposes is a stranger. So if we have that set of facts, we can file for an emergency temporary guardianship and obtain an order that appoints an emergency guardian for a period of 90 days and who is given authority to stabilize the situation and protect the person. Now, sometimes that emergency guardianship may need to lead to a more permanent guardianship, but we'll have a hearing at the end of the 90 days to determine if the person is still incapacitated or perhaps with proper medical treatment and care have been able to resume the ability to make their own medical or financial decisions. If it is a situation involving financial exploitation, we have a new tool that became law a year ago, and we can get an injunction on an emergency basis when we have some evidence to document that financial exploitation is taking place. So that injunction allows us to stop, to turn the spigot off and stop the money running out. We can even have that injunction recorded in the Broward County or whatever county it might be occurring in records so that it protects the home from attempting to be transferred by the perpetrator. It also allows us to share the injunction with the local police or sheriff's department to gain access to the person that is being exploited. And if, for example, the perpetrator is living in the home, to facilitate the police getting that person to leave the home. If you first choose to call the 1-800-ABUSE hotline, which then will filter down to the local level and send a report to Adult Protective Services, they will send an investigator out. However, I do want to share with all of you that even pre-COVID, they don't necessarily act as quickly as we might need them to. So my suggestion is consult directly with an elder law attorney to get the wheels in motion. And if it's an exploitation situation, you might even need to engage a private investigator to assist in that process so we can get evidence fast enough and get into court quickly. Now, we can also ask for an emergency hearing if a medical advance directive is not being properly followed. So let's say that you are not the designated healthcare surrogate, somebody else is, but you have a copy of the living will and you believe that the decisions that the surrogate is making are opposite to what the living will directs. You can file a petition as an interested person asking for an emergency hearing, which will be granted immediately, meaning in under 72 hours, to have the judge take the testimony of you, the surrogate, and any medical professionals that may be witnesses to determine whether the surrogate should be removed by the court and the alternate surrogate named in the document be authorized to begin acting. So we have great legal tools. I just want to encourage everybody, when something doesn't pass that smell test, when it just doesn't meet the ethical standard you believe needs to be met, that is the time you want to pick up the phone and consult with an elder law attorney. The longer you wait, the greater is the possibility that the abuse, the neglect, or the exploitation is going to continue and might reach a point when it's too late to reverse the situation. The fifth, and certainly not the least important reason to call an elder law attorney, is to become aware and connect with resources available in the community, whether it's being connected to healthcare professionals, mental health professionals, support groups, what Broward calls the ADRC, the Aging Disability Resource Center. Other counties might refer to it as AAA, which is the same thing, it's just their Aging Resource Center. Or perhaps you need to speak with somebody at the state agency called SHINE because you have insurance questions. We can also connect you with nonprofit resources in the community. And hopefully once we get through this pandemic, the senior centers will reopen, and those are also a great resource in our community. So elder law attorneys have a lot of different resources that are just as important as you understanding what your financial responsibilities or medical responsibilities are for the person that's incapacitated. So in concluding today's webinar, I want to encourage everybody to be a strong, empowered advocate. And how you do that is you become informed, you communicate clearly, you document what you do in writing, and question. If something doesn't sound right, ask. Where are you getting that answer from, or where are you getting the basis for your information? Always feel comfortable to speak with a supervisor or a manager, and certainly request review by a legal department if your authority under the legal document is not being honored. And last but not least, bring in the elder law attorney. Let them work with you and teach you how to be informed, how to be an effective advocate. So at this time, I invite everybody to unmute their microphones, and I'm happy to take questions.
Stephanie, this is James. I don't have any questions at the time, but I'll reach back to your liaison and set up a discussion one-on-one, because I do have many things that fall into many buckets. I'm the trustee on 3 different estates already, so I will be in touch.
Okay, thank you.
Thank
Jill,
you.
do you have a question?
No, I took copious notes and I will review it again. And if I do, then I will ask you if the one person is basically most of the things, the healthcare surrogate and the power of attorney and all of that. I'm having a situation where he's got short-term memory loss. So I'm having to make a lot of decisions right now. So I guess I need to know what I need to do now. But he, on some days that he can make decisions. Or he wants to.
It's a great question. And, sometimes the issues that we all deal with aren't black and white. They fall within a gray area. So the facts and circumstances of each person and each situation need to be evaluated. So I would encourage you to work with me and let's walk through the process together.
Okay.
Okay.
Thank you.
So I'd like to invite everybody to join me next month. October 21st is our next webinar at 12:30 p.m. and I'm going to be speaking about how elder law and special needs attorneys can help people who are diagnosed with a chronic illness such as cancer. And we are hosting this in honor of Breast Cancer Awareness Month. You can go to the firm's website, www.fl-elderlaw.com, and go to the calendar page to register for a webinar. And if you missed a webinar and would like to watch the recording, you can go to our resource page and register to see a recorded webinar. Also on our website is a document checklist. So even if you're a fiduciary for somebody else, don't forget to take care of your own legal needs. The checklist will help you get organized to have your legal plan created. And we also provide you with a complimentary gift certificate for your initial consultation. So I want to wish everybody a wonderful weekend. Continue to take care of yourselves and stay healthy and stay safe. And thank you for joining me.